The first bellwether trials in the 3M Earplug lawsuit are pretty much wrapped up, but 3M is fighting back and they want the remainder of the cases completely thrown out by claiming government-contractor defense. So we'll take a quick peek, get you up to speed, and see if this is indeed a loophole, if this is a way that 3M can get out of this pickle. Hey, what's up? I'm Russ. I am a 3M investor, and if you want to check out the bridge portfolio where we do hold 3M, head over to dapperdividends.com, click on my portfolio, and check everything out there. The Government-Contractor Defense was established in 1988 after a U.S. Marine pilot named David Boyle drowned in a Sikorsky helicopter training crash in 1983, and his family sued parent United Technologies for a defectively designed co-pilot emergency escape hatch. But since the US government approved the helicopter's specifications and the equipment met those specs, and Sikorsky warned the government of possible dangers, they couldn't be held liable for conduct reviewed and approved by the government. This pretty much falls under the whole thing of you can't sue the government because it claims sovereign immunity, meaning that they cannot be sued unless the government gives their consent, and because lawsuits take place in the courts and the courts are government courts, it would pretty much be unfair. So 3M's defense is seeking to have the cases thrown out because Arrow, the manufacturer, they fulfilled a request by the government and created the CAE V2 earplugs, which could be left in to hear commands but also block out loud noises. So this was really cool. It was called the linear earplug, meaning that it would allow them to hear commands and voices, but it would block out the really loud noises. But the government said they were too long. They needed to be about 1/4 inch shorter for several reasons, one of which they were affecting wearing of the Kevlar helmets. So upon further testing, Arrow warned that, quote, the fact that the shortened earplug was creating a problem in the initial test and the work we had done to try and resolve that problem to get optimum performance for labeling purposes. Basically what happened was that the stem was so short that it was difficult to properly insert the earplugs deep enough into certain individuals' ear canals. So Arrow determined that one of the solutions would be to roll the flanges back on the outer layer of the earplug, and this was deemed acceptable by the government, but they didn't want instructions put on the boxes because they felt that personal training was, quote, the most effective way to train the soldiers, and the government even printed up their own instruction cards with the flange folded back. But in August of 2004, military audiologists began to express concern that soldiers did not know when to use which end of the earplugs. And in 2016, a competitor of 3M's obtained the flange report because of a lawsuit that they had filed, and it was in an unrelated patent infringement case that they got this information, and they alleged that 3M and Arrow hid their findings from the military. But 3M denied the allegations and ended up settling the lawsuit to save further costly litigation fees for $9.1 million in July of 2018. So shortly after that, personal injury lawyers got wind of this, and they started putting out ads to get clients that had served in the military from 2000 until 2015. And away we went. But 3M is arguing that because the military, quote, introduced and required the very feature plaintiffs claim rendered the product defective, which was the shortening of the earplug, and that they warned the government of these issues, that it should have never come this far, and they claim the government-contractor defense. The plaintiff's lawyers replied that this is, quote, yet another attempt by 3M to blame the military for its misconduct, and urged the 11th Circuit Court to reject its arguments. I think it's a very interesting appeal, that it could have legs, and it makes sense that if Arrow was doing exactly what the government wanted, how the government wanted, and they didn't want them to put the instructions on the box because of the issues where they needed to roll the flange back, then I think this could have some merit, and I don't think it's out of the realm of possibility that this all just goes away. But what do you think is going to happen with this whole lawsuit? And hey, when you're done thinking, look at this little box next to my head. There's another video over there where we covered both of 3M's lawsuits, and if you aren't aware of both of their lawsuits, I would strongly recommend checking that video out, and I will talk to you there.